back here again. He's excused. He's not released.
Of course it does.
Okay. Mr. Copeland, you are excused. It is, I guess, possible that you might be called back, but until you hear otherwise, you don't have to come back here again.
It's not over with?
Well, your testimony for right now is over with. The trial is not over with, but you don't need to concern yourself with the rest of it. But as I understand, he's still under subpoena.
Yes, Your Honor.
Okay. And Mr. Engelberger, thank you again for your willingness to step in here for us, for the court. You may be, and obviously stand by as well, because he's not released. But yeah, we would let you know and give you all both some heads up if he's to be recalled. Thank you. What? Okay, thank you. All right. Do you have a short, like hour-long witness?
He's not an hour long. We do have one out there, but he's not an hour long.
Okay. I know we have a couple of matters to deal with. They're not going to, I don't think, take very long. We can start with the next witness, or we can just start fresh in the morning. Jurors, y'all have a preference? The morning. Okay. All right, I'm gonna release y'all for the evening. If you could stick with us for just a second. And with the reminder to not discuss the case with anybody, don't allow anybody to discuss it with you, don't observe in any way, and try to avoid in every way any kind of accounts from anybody or any place about the trial, and we'll see y'all in the morning, okay? All right, this next matter is going to be, it's going to concern a juror. So if the media could please stop recording. All right.
Conviction, but as far as that guilty plea paperwork,
This will be first thing in the morning, 9 a.m. The estimate is somewhere between 3 hours, and I'm thinking more like the whole day, but who knows? Hopefully it'll just be tomorrow in terms of your scheduling, but obviously if I need to reach out to any other judge who expects you, just let me know that, and obviously our chambers will coordinate.
Yes, sure.
Okay.
I'll direct them to your
All right.
chamber.
Okay, and if there's anybody that you think needs to be apprised in advance, just let us know that, and we'll go ahead and do that as well, okay?
Yes, sure.
All right, so we'll see y'all in the morning, 9 a.m.
Yes, sure.
Sharp. Thank you. How fast do you think y'all could find out about, because I kind of wanted y'all to do that over the course of the day? A few moments. Okay. Okay.
Judge, while we're waiting on that, I I want to reiterate, I don't know whether this has been covered, but I do want to reiterate my objection to the admission of any guilty plea agreement or guilty plea transcript against anyone other than the witness on trial. I mean, the witness in the witness stand. So I do want to reiterate that and ask for a cautionary 105 instruction with regard to the admission of the guilty plea and any alleged guilty plea colloquy.
Okay, and I know we've talked about various different witnesses, potential guilty plea colloquies. Remind me what might come up with this particular next witness, Mr. Sledge.
There were two issues. One was the entry whole hog of his prior guilty plea. And the state, I think, made very clear. So there's a video of him taking the plea, and then there is the actual plea agreement paperwork that has been admitted for other witnesses. What I said and what I maintain is that we will not be simply tendering a guilty plea just to tender the guilty plea. We would tender the certified conviction, but as far as that guilty plea paperwork, unless he says something that is not consistent with it, then we won't have a need to tender it as any prior inconsistent statement. Or if there is some challenge to something that he said as a recent fabrication, I mean, unless there is an exception to it, there won't be a need to have it read into the record. I mean, we may tender it as evidence for the record, but not for presentation or anything to the jury unless something happens during his testifying.
All right.
That was the first.
You're not intending to introduce anybody else's guilty plea with this witness, are you?
No.
Well,
Mr. Harvey, can you give me a little bit of more info on what it is you might be referencing?
The guilty plea agreement.
Of anybody else?
No, of the witness.
Oh, you said you were objecting to the
Admission of the guilty plea agreement as to anybody other than that it represents and can be used as substantive evidence against any of the other defendants on trial.
Yeah,
it can be used traditionally, and there are 100 cases on that point.
I understand what you mean now. I thought you meant somebody else's guilty plea agreement.
No.
You mean its use against somebody else?
Yes, that's correct.
Okay, and do you have a proposed instruction on that? What did he plead to?
Your Honor, he pled to the indictment. So two things. One, I'm not certain why Mr. Harvey is saying that a 105 instruction is necessary. As it relates to this particular witness, he will be on the stand testifying, and his testimony would be admissible, especially as it relates to count one, as to all of the defendants. If he says something on the stand inconsistent with what he has said previously, then that prior inconsistent statement would be substantive evidence against all of the defendants, if that comes to it. But I don't know that it will come to that, so I can't really speak to,
All right, yeah.
Okay.
So, I mean, just have something ready, and it may just depend upon what the circumstances are.
Well, the rule is as follows. One person's guilty plea or conviction may not be used as substantive evidence of the guilt of another. The evidence, however, a co-defendant's guilty plea is admissible at trial, provided that, quote, the evidence serves a legitimate purpose and the jury is properly instructed about the limited use they may make of it, close quote. That's United States versus Deloach at 34 Fed 3rd 1001 at pinpoint 1003, as discussed in United States versus Clay. In United States versus Clay is, I don't know whether you want a Westlaw or Lexus site, but 2021 U.S. Appeals Lexus 36080 or 2021 Westlaw 5795330. That's the general rule.
Judge, I think that's the general.
That's the general rule. That's not
Yes.
when we're talking about something like a RICO count.
It's the general rule as to anything. He can testify, but the plea agreement cannot be used against everybody else. That provision of the statute and the gang statute has been held unconstitutional. We've argued about this before, but his guilty plea can't be used against anybody else.
I disagree with what Mr. Harvey is saying. I think as it relates to this witness's guilty plea and anything, if it's a prior inconsistent statement, federally it may not be allowed, but under the Georgia rules of evidence, a prior inconsistent statement is substantive evidence. So given that it would be substantive evidence against each of these defendants as to count one, a limiting instruction would not be warranted. A 105 limiting instruction, as Mr. Harvey has requested, would not be warranted. So I'm not certain what he's proposing to the court, so I can't really object specifically to what he's proposing.
It's not.
But I argue that.
Sorry.
Please don't
I'm sorry.
interrupt
I'm sorry. I
the
thought she was
attorneys
done,
when they're
and
talking.
I apologize.
Okay.
But I would, at this point, my position is that a 105 limiting instruction isn't necessary. We're not talking about someone that they cannot cross-examine. We're not talking about somebody who's unavailable. We're talking about a person who is on the stand as a witness that will be asking questions.
Okay, so I don't think Mr. Harvey is talking about a prior inconsistent statement being used as substantive evidence. He's talking about the guilty plea itself being used as evidence against any of the people here on trial, right?
That's correct. That is correct. The guilty plea agreement can be used against Mr. Sledge, but not against the other defendants. Show the court a case. I want to see a case where
All right, talk to me.
where it says that a 105 instruction and a guilty plea of even a testifying co-defendant doesn't require a 105 instruction. The case that I cited to the court, which cites a whole series of 11th Circuit cases, is a case that deals with a testifying witness. It is not just unavailability. And fine, if we can see a case that says otherwise, we'll be glad to discuss it. In the meantime, I'm moving in limine and want a 105 instruction.
All right, well, give me something that you would like proposed, and why don't we all meet here at 8:30 in the morning, since we'll need to hash all of this out potentially before we get the next witness on the stand.
Yes, Your Honor.
I'll be here at 7:30.
And what I heard Mr. Harvey say that he's not speaking about the certified conviction. He's talking about that plea form where there were factual acknowledgments that were made. And that is what we discussed the last time. And that is what I told the court that I would not be using unless there was something inconsistent said. And that is why I said it would be a prior inconsistent statement that is admissible as substantive evidence. And Mr. Harvey is asking us to prove a negative, when in fact, the case law that he is citing is not applicable to this circumstance.
Judge, I am talking about a plea agreement. There
Are you
is a
talking about
December.
the part that he signs and he says, yes, I acknowledge X, Y, and Z are true, or whatever it is
Yes,
he says?
yes, that's correct.
Okay. All right. See y'all at 8:30 about it, and send anything you want to have me consider in the meantime to Ms. Firstfield.
And
All
Your
right,
Honor,
anything else?
We have a response for the Antonio Sledge interview, Your Honor.
Okay,
It appears that there's only one interview to answer the question. And also, Your Honor, and I can do this now or when the jury is, I want to just make sure that the exhibits that we discussed today were tendered and admitted, Your Honor. And so I just wanted to go over those numbers again.
we can do that now.
So the exhibits that we tendered and moved for admission was 399Y, 401Y, 402Y, 403Y, 404Y, 405Y, 406Y, and 407Y.
And you think those were all admitted?
Yeah,
Or you're just
if they
trying to
weren't,
make
I want to
sure?
make sure that they are.
I know, so remind me what 399Y was?
399Y was the law and crime clip where I asked Mr. Copeland about reading the Hertz records.
Okay, yeah, I don't know if you tendered, or, well, I mean, you must have because you played it, so yeah, that was admitted, and then I know 401 and 402Y were, and then obviously anything that you played was.
Yeah.
Is that what everything else was?
So 401 and 402 were the
Guilty plea
document
forms,
Yes.
yeah.
And then
Those are in,
and then 403, just to confirm, was okay, 405Y, I can start there, was the video clip of Mr. Steele and Mr. Copeland and the portion of the We Killed Nut call. 406Y was the June 16, 2015 jail call. 407Y was the June 13, 2015 jail call.
okay, those are in.
And then I just need to look and see what 405.
I mean, a lot of this is like it was already in, and now they're just excerpts. And so they already are in. They're just labeled as smaller pieces of the larger piece that's already in.
No,
right?
no, these were like the law and crime. The law.
Not the law and crime things. Those are in. And the two guilty plea forms are in.
Correct.
But all of the things that are just, snippets of things that were already in.
Yeah.
I mean, they're already in. It's just more for convenience that y'all are relabeling them.
Yes, Your Honor.
Okay, so was there anything else other than those groupings of things?
Okay, no, that was it, Your Honor.
Okay, all right. Anything else before we break for the day? 8:30. Okay. 8:30. See y'all at 8:30. All right, we are adjourned for the day.
We can stop.